You're at home, it's early morning. There's a knock at the door. You look through the window and see men in jackets that say, "Ice, your heart is racing. You don't know what to do." And the next 60 seconds will determine everything. Every day across America, thousands of people open their doors and hand ICE agents access they were never legally required to give. They don't know that 4 words, said clearly, said calmly, can legally end that encounter at your door. I've spent years studying immigration enforcement law, analyzed hundreds of ICE encounter cases, and reviewed the actual constitutional framework that governs every one of these interactions. What I'm going to give you today are the exact words, the exact legal basis behind them, and the exact situations where they apply and where they don't. Because knowing the limits of your rights is just as important as knowing the rights themselves. This is educational content only, not legal advice. For your specific situation, always consult a... And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Qualified immigration attorney. But what you're about to learn is grounded in the United States Constitution, federal court rulings, and the actual policies of immigration and customs enforcement itself. Let's go. Mistake 1. Opening the door. Here's the mistake. ICE knocks. Most people open the door automatically. It feels rude not to. It feels suspicious not to. So they swing the door open wide, and suddenly they're face to face with federal agents who are now, legally speaking, in a much stronger position than they were 10 seconds ago. The scenario, it's 6 a.m. You hear a hard knock. You open the door. An agent says, "ICE, we're looking for someone at this address." You step back. You start explaining. You let them talk to you from inside your doorway. And without realizing it, you've just given up the first and most important layer of protection the law gives you. Why people do it? Because opening a door feels like basic human courtesy. Because refusing feels like you have something to hide. Because most people don't know that opening your door to law enforcement is not legally required. And that keeping it closed is not evidence of guilt. Here's the legal reality. The Fourth Amendment to the United States Constitution protects you against unreasonable searches and seizures. And that protection applies to your home more than anywhere else. The Supreme Court established in Payton v. New York, 1980, that law enforcement cannot enter a home without a warrant, consent, or exigent circumstances. This rule applies to ICE agents exactly as it applies to any other law enforcement officer. ICE itself has acknowledged this in its own policy guidance. A 2011 ICE memorandum explicitly stated that agents should obtain a judicial warrant before entering a residence when consent is not given. The evidence problem. If you open the door and step back, courts have sometimes interpreted that physical movement as implied consent to enter. If you speak to agents from inside the home rather than from a barely cracked door, that interaction can be used to establish probable cause for further action. The body cam is recording. Every word you say, every movement you make is documented. Officer psychology. ICE agents are trained to knock early in the morning when people are disoriented. They're trained to use authoritative language and a sense of inevitability to encourage voluntary compliance. We just need to talk. This will only take a minute. You're not in trouble. These phrases are designed to get you to cooperate before you've thought through whether you're legally required to. The correct move. Do not open the door. Speak through the door or through a window. And say these words. I do not consent. 4 words. That's line 1. I do not consent. Say it clearly. Say it calmly. I do not consent to entry. You are not being rude. You are exercising a right that the Fourth Amendment explicitly gives you, that the Supreme Court has upheld since 1980, and that ICE's own policy acknowledges. Now, if they have a judicial warrant signed by a federal judge with your name and address on it, they can enter regardless. But that's the critical point. Ask through the door, do you have a judicial warrant? If they do, they are required to show it. If they don't, your 4 words are a legally valid refusal that agents must respect. Bottom line, do not open the door. Do not imply consent through physical movement. Say, I do not consent, and ask whether they have a judicial warrant. That alone changes everything. But refusing entry doesn't mean the encounter is over. ICE. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Agents may stay outside. They may watch the property. They may attempt to speak with you further. And this is where mistake 2 becomes dangerous, because most people don't understand the difference between a judicial warrant and an administrative warrant. And that distinction right there is where people lose rights they didn't know they still had. Mistake 2. Not knowing the difference between warrant types. Here's the mistake. An ICE agent at your door holds up a document and says, warrant. You see an official-looking piece of paper with a government seal. You assume this means they can enter. You open the door. But there are two completely different documents that the word warrant can describe. And only one of them legally requires you to let them in. The scenario, ICE comes to your home. An agent holds up a Form Y-200 or a Form Y-205. These are administrative warrants, also called warrants of removal or warrants of deportation. They are signed by an immigration official, not a judge. They do not authorize entry into a private home. The agent calls it a warrant. You hear warrant, you open the door. But you just consented to entry that the Constitution did not require you to give. Why people do it? Because the word warrant sounds absolute. Because a government document with a seal looks official and final. Because no one told them there are two kinds and only one carries judicial authority. Legal reality. A judicial warrant is issued by a federal judge under the Fourth Amendment. It must specify the place to be searched and the person or things to be seized. It authorizes law enforcement to enter your home. An administrative warrant, including ICE forms I-200 and I-205, is issued by an immigration officer, not a judge. It does not carry the judicial authority required by the Fourth Amendment to compel entry into a home. The Ninth Circuit Court of Appeals affirmed this in Morales versus, yet Chadwick and related cases. Multiple federal courts have consistently held that administrative warrants do not override the Fourth Amendment's home entry protections. The evidence problem. If you open the door after seeing an administrative warrant, you have just consented. There is no legal argument left. The body cam shows an open door. The agents are inside. Anything they observe or discover is now admissible. Officer psychology. Agents know most people don't know the difference. They're not lying when they say warrant. They do have a warrant, just not the kind that obligates you to open the door. The correct move. Through the door or window, ask, is that a judicial warrant signed by a federal judge? If the answer is yes, ask them to slide it under the door so you can read it. Confirm that it has your name, your address, use and a judge's signature. If the answer is no, or if they present an I-200 or I-205, you say, I do not consent to entry. You are legally protected in doing so. That's line 2. Do you have a judicial warrant? Bottom line. The word warrant is not enough. Ask specifically about a judicial warrant. If they can't produce one signed by a federal judge with your name and address on it, your 4 words still apply. But knowing your rights at the door is only half the equation. What happens if you're stopped not at home, but in public, on the street, or in your car? Because mistake 3 is thinking your constitutional protections only exist inside your house. Mistake 3, thinking the Fourth Amendment stops at your front door. Here's the mistake. People believe that if ICE stops them outside, on a sidewalk, at a bus stop, in a parking lot, the constitutional protections evaporate. So they answer questions. They hand over documents. They tell agents where they're from, how long they've been here, who they live with, all of it, without realizing that the Fourth and Fifth Amendments apply in public too. The scenario. You're walking to your car. An ICE agent approaches. Excuse me, where are you from? Can I see your ID? You answer. You explain. You try to be cooperative because you don't want to escalate. But every answer you just gave is being recorded, and it can be used in removal proceedings against you. Why people do it? Because refusing to talk to a federal agent on a public street feels different than refusing to open a door. It feels dangerous, it feels illegal, but it isn't. Legal reality. The Supreme Court established in Terry versus Ohio, 1968, that a brief investigative stop in public requires reasonable articulable suspicion of criminal activity. Immigration status alone is not a criminal matter. It is a civil enforcement issue. In United States versus Brignoni-Ponce, 1975, the Supreme Court ruled that appearance alone, including apparent ethnicity, cannot constitute the sole basis for reasonable suspicion in an immigration stop. Additionally, the Fifth Amendment right against self-incrimination applies to everyone on U.S. soil, regardless of immigration status. This has been consistently affirmed by federal courts. You are not required to answer questions about your immigration status, your birthplace, or how you entered the country. The evidence problem. Answering questions in public is no different than answering them on camera in a courtroom. Every statement you make to an agent can be introduced as evidence in removal proceedings. Inconsistencies between what you say in a street encounter and what you say later can be used to undermine your credibility entirely. Officer psychology. Public stops are designed to feel casual, even friendly. Just a quick question. I'm not accusing you of anything. The conversational tone is deliberate. It encourages you to keep talking, to explain, to justify yourself, when none of that is legally required. The correct move. If stopped in public, you have the right to ask, am I being detained or am I free to go? This is line 3. It is the same question analyzed in traffic stop law, and it applies here with identical legal force under Terry versus Ohio. If the agent says you are free to go, leave calmly. If the agent says you are being detained, you invoke line 4. You state clearly, I am exercising my Fifth Amendment right to remain silent. You do not have to answer where you are from. You do not have to state how you entered the country. You do not have to provide documents beyond what your specific state requires in a lawful detention. And even then, consult an attorney about what your state's laws require, as they vary. Bottom line, the Constitution does not check immigration status. The Fourth and Fifth Amendments apply to everyone on U.S. soil. Ask if you're free to go. If not, say nothing and invoke the Fifth. And that brings us to the most critical mistake of all, because even people who know their rights make this one. They invoke their rights, but they invoke them wrong. And the Supreme Court, in a ruling most people have never heard of, said that. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. It can cost you. Mistake 4. Staying silent without saying why. Here's the mistake. An agent is questioning you. You know you don't have to answer, so you don't. You stay quiet. You think your silence is the Fifth Amendment working for you. But in Salinas versus Texas, 2013, the Supreme Court ruled that if you are not in custody and you go silent without explicitly invoking the Fifth Amendment, that silence can be used as evidence against you. The scenario. An ICE agent asks, how did you enter this country? You don't answer. You just look at the ground. The agent notes your silence. Weeks later, in an immigration court hearing, the government argues, when asked directly how you entered, you refuse to answer. That refusal suggests consciousness of illegal entry. Why people do it? Because silence feels safe. Because silence feels like saying nothing. But legally, silence without invocation is not protected silence. It's just silence, and it can mean whatever the government argues it means. Legal reality. Salinas versus Texas, 2013, established that a person who is not in custody must affirmatively and explicitly invoke the Fifth Amendment privilege. The actual words matter. Silence alone is not invocation. This ruling was not limited to criminal proceedings. Immigration courts have cited the principle that a person's voluntary non-answers made without explicit invocation can be considered in assessing credibility. The evidence problem. Body cam footage showing you saying nothing, it's with no explicit invocation, looks like evasion. Explicit invocation looks like someone who knows their rights. The distinction is everything. Officer psychology. Agents are trained in the Salinas framework. They know that sustained silence without invocation is usable. They may continue asking the same question in different forms, waiting for either an answer or a moment where your silence pattern breaks. The correct move. Say the words, out loud, clearly. I am exercising my Fifth Amendment right to remain silent. That's line 4. That is your explicit invocation. Once you say it, stop talking. Don't explain why, don't apologize, don't add anything. The invocation is the shield. Silence after the invocation is protected. Silence before it is not. Bottom line, never stay silent without saying why. Always explicitly invoke the Fifth Amendment before going silent. 4 words on their own aren't enough. The invocation is what activates the protection. Here's what you've learned today. 4 legally grounded responses that the Constitution actually supports. Line 1. I do not consent. At your door at any entry point, without a judicial warrant, no one is legally entitled to enter your home. Line 2. Is that a judicial warrant? An administrative warrant is not the same as a judicial warrant. Know the difference. Ask the question. Line 3. Am I free to go? In any public encounter, this question forces an agent to either release you or justify a detention under Terry versus Ohio. Line 4. I am exercising my Fifth Amendment right to remain silent. Say it out loud, explicitly. Every time before you go silent. Write these down. Put them somewhere you will have them. So you practice saying them out loud until they are automatic. Because when the knock comes, your heart will be pounding and you will not have time to think. One final thing. If you are detained, you have the right to contact an attorney and the right to contact your consulate. Ask for both immediately and say nothing else until you have legal representation. This is educational content only. Immigration law is complex, varies by individual circumstance, and is subject to ongoing court decisions. Consult a qualified immigration attorney for guidance on your specific situation. The people who protect themselves in these moments are not the ones who panic and talk. They are the ones who know exactly what to say and exactly when to stop.